insurance. Just a couple of words about our work as a committee. We've been working since July 2020 with a very interesting mix of individuals from different backgrounds, including Martin Bondine, who is one of our panelists today. What brings us together is a strong conviction that promoting health and safety and wellness in general in organizations will make organizations more successful too. Key themes being addressed include resilience and organizational culture, work-life balance, gender burden sharing, health and safety, and the mental health service provision in Malta. Of course, the various challenges presented to employers under COVID-19 have featured strongly on the committee's radar and no doubt will feature today. Today's agenda is a very interesting one, and we've got quite a lot of interest from participants. Protecting the health and safety of our employees and members of the public who may be affected by our activities is an essential risk management activity and must be led by the board of every company. Directors and officers can be held both collectively and individually responsible for breaches of duty in this area, and we'll hear more about this later on today too. The aim of today's webinar is to point towards key aspects of promoting health and safety within our organizations and the maintenance of a robust health and safety culture. This positive culture can lead to benefits. It's not just to conform with legislation. Okay, it can lead to reduced risk and costs, improved reputation, also among suppliers, partners, and most importantly, employees, and increased productivity with healthier, happier, and more engaged stakeholders all around. I would like to thank the OHSA in particular, and in particular Dr. Mark Gauci, in fact, for enthusiastically, and David Schwirek and Melina Mercia for enthusiastically joining in our efforts to create more awareness about this subject. Today's event will touch on the various duties of business leaders, including the assessment of the risk, setting health and safety policy, and involvement of employees. The COVID-19 scenario, mental health risks, and actual local case law relating to accidents at work will be reviewed, as will be the insurance aspect. I would like to stress that we would welcome feedback. Please use the chat to ask questions during a presentation. If we have time, we'll answer the question during the particular presentation, but otherwise we'll add your question to the list for the panelists. Okay, so we should have half an hour at the end for the panelists between 3 and 3:30. Thank you very much. At this stage, I'd like to introduce Perry's David Schwirek. I'm sure most of you know that David is the former president, immediate past president, in fact, of the Chamber of Commerce. He's recently been appointed chair of the Occupational Health and Safety Authority, so it's really opportune to invite him to say a few introductory words. Thank you, David.
Thank you, Catherine. I will thank you for the introduction, and good to hear you. And I must say that in a few words, maybe I can express some emotion here and some thinking, primarily related to what I perceive to be an economic transition that all the countries in the world will have to go through, and this probably relates to climate change primarily, but anything related to risk is going to be certainly the prime driver, and therefore. When I see an insurance company such as Atlas and the banks, mind you, together with an employer body such as the Chamber of Commerce, of course, come together to support business and frankly support an economy that will transition into the new and will, of course, try to carry out all actions to the risk and ultimately also to be able to compete in an ever changing world is certainly the right way to go. And I am, of course, partly conflicted with some conflict here, of course, because I had my past leg one way and my current leg another way. But of course, have an interest in this is to actually understand, appreciate, and thank all of the people at the chamber, all of staff members, including Tim, with us this afternoon, Catherine and her team, of course, dealing with such an important aspect of, I would dare say, business competitiveness, which is the wellness and the health and, of course, the safety of our employees and therefore the workplace, as a particular instrument towards success. So I will stop here, and I look forward to an engaging discussion conversation. And if there's anything you wish me to add during the proceedings, I'll be more than happy to do that. Thank you.
Thank you very, very much, David. The first presentation is a very practical one. Martin Bondin is a member of the Health and Wellness Committee, and his position is his Data Protection Officer and Health and Safety Manager at the Vassallo Group of companies, which has a very, very diverse range of business activity, from care homes to construction to hospitality. So he's really, I think, perfectly placed to give us an overview of what organizing a health and safety calendar is all about. Martin is a retired armed forces, is retired from the Armed Forces of Malta. He was an officer in the Armed Forces, and he joined the Vassallo Group in the capacity of facility manager originally in May 2014. In 2019, he was appointed Group Health and Safety Manager, and he promotes and coordinates his function across the different diverse companies of the group. So Martin, please go ahead.
Thank you, Catherine. And am I sharing, please?
Not yet.
Okay, sorry about that.
Okay.
Wait.
Do you want?
Okay. Thank you, Catherine. And once again, good afternoon to you all present for this webinar. During my short presentation, and as Catherine has mentioned in her introduction, I shall be looking at an organization's health and safety calendar from a practical perspective. Although there is quite a lot of obligations that an employer must meet on a yearly basis, I shall be focusing on those particular objectives which I believe are essential to ensure minimum standards required at every place of work. As introduced, I am the Health and Safety Manager at Vassallo Group, and my role in this group is to coordinate and oversee the health and safety function across the organization in accordance with our health and safety mission statement. For those of you who are not familiar with Vassallo Group, the group was set up over 75 years ago at the end of the Second World War. Initially, the group focused on the construction sector, diversifying operations into other sectors in the subsequent years. Nowadays, the group employs over 1,900 employees in various sectors, ranging from property and construction, furniture and interiors, care for the elderly and disability, catering and hospitality, architecture, and education. Before moving on to the health and safety calendar, it is very much important to remember that health and safety in Malta is regulated by the Occupational Health and Safety Law, which can be found in Chapter 44 of the Laws of Malta. 24 subsidiary legislation focusing on particular subjects such as work equipment, first aid, pregnant employees, young workers, and workplace minimum standards can all be found in the subsidiary legislation. The Act itself and subsidiary legislation can all be easily downloaded from the government's website. Health and safety needs to be given the same importance as other important functions such as budgeting and finance in any organization, as there are tangible benefits for both employer and employee to be gained by having a sound health and safety plan in place. Suffice to say that apart from the moral and legal obligation, an organization can suffer direct and indirect costs if health and safety is not managed correctly. It is therefore significant for an organization to have a health and safety policy in place to set the organization's principles on health and safety. A policy signed by the Chief Executive Officer will send a message that the management has health and safety at heart. Such policy should also be the foundation stone of good health and safety management in the organization, as it will set out the organization's general approach and commitment to achieving particular aims and objectives. Overall, the policy will provide a framework of general and specific health and safety responsibilities for staff and guidance on the detailed operation arrangements to be taken to protect employees and others from harm as a result of work activities. It is a very good practice for any organization to organize and keep a health and safety file. A well-organized file will help any organization and any person responsible for health and safety to organize his job well. Ideally, this file should contain, amongst other documents, the health and safety policy, risk assessments, records of training, fire drill records, minutes of health and safety meetings, accidents and incident reports, evacuation plans, and equipment maintenance records. A well-kept file will also ensure that an organization's corporate image and compliance with the health and safety is maintained, especially when an organization is visited by a regulatory body such as OHSA. I believe that the updating of the place of work risk assessment should be top priority on the to-do list in the yearly calendar. It is the duty of every employer to carry out a suitable, sufficient, and systematic assessment of all the occupational health and safety hazards which may be present at the place of work, and the resultant risks involved concerning all aspects of the work activity. The risk assessments can be conducted internally by the designated competent person helping the employer in the role of health and safety. Or if the competency is not found within the organization, the employer can engage the services of external competent persons to assist him in this regard. The risk assessments need to consider the risks to the health and safety of workers to which they are exposed whilst at work, as well as the risks to the health and safety of other persons, including visitors to the place of work. This means that apart from your employees, you would also need to take into consideration the safety of any visitors, such as clients, delivery persons, contractors, etc., who may visit your premises from time to time. It is important to remember that risk assessments are reviewed whenever there is any major change in working conditions, and whenever the employer has reason to suspect that they are no longer valid. Following on the workplace risk assessments, we also need to ensure that any vulnerable persons are also covered through their respective risk assessments. Thus, for instance, we need to ensure that young persons below the age of 18 years are covered by an assessment. We all know that young persons are inexperienced, and also through their eagerness to impress their first employer, they would be taking on assignments without any consideration for their safety at all. Likewise, we also need to ensure that pregnant employees are covered by a risk assessment, ensuring that new and expecting mothers are working safely and in accordance with the applicable regulations for this category of workers. When taking on disabled persons, we are also required to conduct a specific assessment for this category of employees, since the safety requirements of such might be different from that of other workers. Particularly, we might need to look at ergonomics, escape procedures, and welfare facilities. Meeting health and safety reps is another essential item on the calendar, as the appointment of health and safety representatives at the place of work is another legal obligation deriving from the Health and Safety Act. Workers' representatives are chosen from amongst the workers themselves to act on their behalf with the employer on matters related with health and safety issues at the place of work. On the other hand, the regulations require the employer to consult the representatives on measures that could substantially affect health and safety. Representatives have the right to make representations with and to make proposals to their employer on any matter which may affect the health, safety, and welfare at work arising from the risk assessments, accidents and incidents, the engagement of competent persons to assist management in the organization of health and safety in the company, and the planning organization of training. Meetings with management are to be held on a regular basis. It is best practice for minutes of such meetings to be held so that points arising from such minutes can be actioned and followed up. Providing health and safety information and training helps employers to ensure that people who work for them know how to work safely without risks to health and to develop a positive health and safety culture where safe and healthy working becomes second nature to everyone. It also helps employers meet their legal obligations to protect the health and safety of their employees. On the other hand, effective training will contribute towards making employees competent in health and safety, helping businesses avoid the distress that accidents and ill health can cause, and helping businesses avoid the financial costs of accidents and occupational ill health, such as damaged products, lost production, and demotivated staff. We also need to remember that insurances might not cover costs related to accidents if we cannot prove that a worker was adequately trained before being assigned a particular job. As a general rule, employees need to be provided with training on recruitment, in the event of a transfer or a change of job or task, in the event of the introduction of new work equipment or a change in equipment, on the introduction of new technology, and on the introduction of new work practices. Fire safety. The regulations require an employer to have an adequate number of workers responsible for the implementation of the measures required for firefighting and for the evacuation of workers. The regulations also require that any workplace is equipped at all times with suitable and sufficient firefighting equipment and with fire detectors and alarm systems as necessary, and that all equipment is fully functional and maintained. It is therefore of vital importance that the number of fire marshals is maintained and that their training refreshed in accordance with their certification expiry. Important also is the need to ensure that firefighting equipment, such as fire extinguishers, fire detection systems, and fire alarm panels, are maintained and certified accordingly. Fire drills also need to be conducted at least once every 6 months, and records kept as evidence. As mentioned earlier, with regards to training, you will find that insurances will have a difficulty covering any claims related to a fire incident in the absence of such certifications. The first aid regulations require that at a place of work, there must be the presence of a first aider to render first aid to employees if they are injured or become ill at work. The regulations require a minimum of 1 first aider for every 100 employees in a workplace with relatively low hazards, including offices, shops, and banks, and require 1 first aider for every 50 employees in a workplace with greater degree of hazards, such as factories, ship repair and shipbuilding yards, and docks. Where 200 or more employees are at work in a place of work or whose work where the type of activity or the frequency of accident dictates so, the employer is required to provide a suitably equipped first aid room which shall be readily accessible to stretchers. First aiders at the place of work can be chosen amongst workers capable of taking control in an emergency situation. Chosen first aiders need to attend an appropriate first aid course paid by the employer at an established institution which is accredited by the Malta Qualifications Recognition Center. An adequate number of first aid boxes also need to be provided at the place of work. The contents of these boxes should be as those listed in the first aid at work regulations. First aid boxes need to be replenished and expired items replaced accordingly. In order to ensure work equipment does not deteriorate to the extent that it may put people at risk, employers are required to keep equipment maintained in an efficient state and in good state of repair. Such effective maintenance can not only help in meeting the legal requirements, but can also serve other business objectives, such as improved productivity and reduced environmental impact. The frequency and nature of maintenance should be determined through the risk assessment, whilst taking full account of the manufacturer's recommendations, the intensity of use, operating environment, such as the effect of temperature, corrosion, and weathering, user knowledge and experience, and the risk to health and safety from any foreseeable failure or malfunction. It is important that all inspections are documented and records kept for a minimum period of 2 years. Unfortunately, and notwithstanding all the efforts that we take to ensure a safe and healthy workplace, accidents still happen. Being a simple slip, a cut, bruise, or fall from a ladder all require an investigation. Likewise, we also need to monitor ill health, which, although this does not arise from a direct trauma, can result in chronic illness to the worker due to bad work practice such as musculoskeletal disorders arising from bad posture from sitting in front of a computer monitor or exposure to noise or dust. We also need to investigate and record near-miss incidents, as these can help us avoid accidents from happening in the future. The Act requires an employer to inform OHSA in the case of a death or major injury to any person, in the case of an employee being incapacitated for work for more than 3 consecutive days, and in the case of any other injury which result in the injured person being kept in hospital for more than 24 hours other than for observation. That, ladies and gentlemen, brings me to the end of my presentation. Thank you for your attention. I now pass back the webinar to Catherine.
Thank you very much indeed, Martin. I found your presentation to be really very well ordered and will be a good guide, hopefully, for participants, because we can circulate the presentation afterwards. Our next speaker provides quite a big contrast to Martin, because he's talking from the legal point of view. So we chose someone to talk from the practical point of view, mentioning the legislation and going into the tasks which are done on an annual basis and which we have to look at. And now we're talking to Dr. Melino Mercea, who's a lawyer by profession. He's got a special interest in the area, in the field of occupational health and safety. And in fact, he currently heads the International Affairs section at the OHSA, managing the implementation of national activities of the European Agency for Safety and Health at Work. So Melino will be giving us examples of case law and hopefully looking at this from another aspect, but adding to our body of knowledge. Thank you very much. Melino, over to you.
Thank you, Catherine, for the introduction, and thank you, Malta Chamber, for the invitation. Now, the topics that I'm going to cover are quite vast, and it's impossible to cover everything in just 15 minutes. So what I'm going to do is to introduce you to the concepts of criminal and civil liability in occupational health and safety, and then proceed to cover the duties of employers that are frequently cited by the Maltese courts in cases concerning workplace accidents. Now, let me share the screen. Can you see it, Catherine?
Yes, thank you.
Okay, so as you're well aware, as an area, health and safety is regulated by the Occupational Health and Safety Authority Act, which is Chapter 424 of the Laws of Malta. Basically, it's the act that enables other health and safety regulations to come into power, because health and safety is also regulated by a number of subsidiary regulations. In fact, there are roughly 25 subsidiary regulations which address specific hazards, activities, and generic issues. Obviously, they also impose additional legal duties upon employers. So it's very important that employers know which regulations apply to their business and to be aware of the additional duties found in such regulations. Now, the Act imposes its first and most important duty on three persons. We have the employer, we have the self-employed person, and we have the worker. And this duty is called the general duty of care. As a duty, it might sound quite generic and simple, but in reality, it's quite onerous. In fact, it features in all cases concerning workplace accidents, and it's also the most cited duty by OHSA in criminal proceedings. In the case of employers, the general duty of care is found in Article 6 of Article 1. According to this article, employers have the duty to ensure the health and safety of all persons, and I repeat, of all persons who may be affected by their activities. Now, the Act refers to all persons, so it doesn't limit itself to workers. This means that under health and safety law, the employer's duty of care is to a certain extent extended to third parties, like for instance visitors, members of the public, or clients. This general duty of care is further expanded by subsidiary regulations. Basically, the duties found in subsidiary regulations interlink and reinforce the general duty of care found in the Act. For example, the failure to carry out a risk assessment in terms of the general provisions, health and safety regulations would automatically mean that you failed in your general duty of care. So there is an interlink between the subsidiary regulations and the Act. Now, health and safety legislation is based on the principle that those who create the risk must address such risk, and that's the reason why most duties are imposed upon employers. However, workers also have a number of responsibilities. In fact, if you see Article 7 sub-Article 1 of the Act, it makes it clear that workers have the duty to safeguard their own health and safety, as well as that of other persons who may be affected by their activities. Further duties are also found in the general provisions for health and safety at work regulations. For instance, they have the duty to make correct use of machinery, to refrain from removing safety devices, something which unfortunately happens on a daily basis, and they also have the duty to make correct use of personal protective equipment. Now, with regard to self-employed persons, these fall under the definition of workers. So, the general duty of care imposed upon workers is also applicable to self-employed persons. However, self-employed persons have certain duties which are not applicable to workers, like for instance the duty to carry out a risk assessment. The duty to carry out a risk assessment is only imposed upon the employer and the self-employed person. So there's some changes, some interaction between the duties imposed upon employers and the duties imposed upon self-employed persons. Now, let's start with criminal liability. The message is clear. Breaching health and safety legislation is a criminal offense. So, if, for example, an employer breaches health and safety regulations, he may be charged under the Act and or subsidiary regulations. For example, he may be charged under Article 6 of Article 1 of the Act for failing to ensure the health and safety of his employees. And he may also be charged under, for instance, the general provisions for health and safety at work regulations for failing to carry out a risk assessment, for failing to provide workers with training or with information, and the list goes on. It all depends on the circumstances of the case. But, and this is very serious, in cases concerning workplace accidents which result in injuries or death, the person, let's say for instance the employer, may also be charged under the criminal code, mainly under Article 225 and Article 226. Article 225 deals with involuntary homicide and Article 226 deals with involuntary bodily harm. And it's quite common to be charged under both the criminal code and the health and safety regulations. Obviously, I'm referring to situations involving workplace injuries and deaths. Now, proceedings for an offense against health and safety regulations are initiated before the Court of Magistrates. With regard to the penalties, the Act provides that if a person is found guilty, he may face a fine or imprisonment, or both. As you can see, the fine is in the region of 450 something, but does not exceed 12,000 euros. So in cases concerning breaches of health and safety, the courts will apply these penalties. But if the fact constitutes a more serious offense under the criminal code, like for instance involuntary homicide, then it's the punishment provided in the criminal code that will apply. Having said that, there are certain situations where breaches of health and safety regulations would only result in the provision of administrative fines. Such fines are issued in terms of the occupational health and safety payment of penalties regulations. Basically, these regulations list the offenses and the amount of fine for each offense. It's either 250 or 450 for each offense, depending on the type of breach. As I said, involuntary homicide is addressed by Article 225 of the Criminal Code. Basically, this article deals with a culpable conduct, namely imprudence, carelessness, and unskillfulness in one's art or profession. And we also have non-observance of law. So basically, we have imprudence, where, for example, an employer fails to take the necessary precautions to be able to foresee and prevent a harm. And we have carelessness, which basically refers to negligence, where, for instance, you take a risk without even thinking of the consequences of your actions. And then also we have unskillfulness in one's art or profession and non-observance of law, both of which are quite self-explanatory. Imprudence, carelessness, and non-observance of law feature constantly in cases concerning workplace accidents. In fact, the majority of cases are caused due to negligence, but we also have cases due to unskillfulness in one's art or profession. Now, with regard to non-observance of law, the courts have held that the lack of observation of rules intended to protect third parties, like for instance health and safety regulations, would amount to negligence. Now, with negligence comes foreseeability. Foreseeability is an important element both in criminal and civil law, especially in determining whether, for example, an employer was negligent with respect to his employees' health and safety. So, in cases concerning workplace accidents, the court would analyze in detail whether the accident was foreseeable or not. In most cases, and in my opinion, accidents are quite foreseeable. So basically, you would be liable if you fail to foresee something which was reasonably foreseeable. So once the risk or event is foreseeable, employers are expected to take immediate steps to protect their workers. Now, in cases of non-observance of regulations, there's an absolute presumption with respect to foreseeability, in that you can't argue that the act was not foreseeable because there's a presumption by law. Another important element besides foreseeability is causal link. There must be a link between the act or omission, because it can be an act or an omission, and the end result, which is death or bodily harm. Like, for example, the failure to install a safety guard on a machine and the injury suffered by a worker. There's a link between the failure and the injury suffered by the worker. If there's no link, there's no liability. These concepts obviously also apply to the offense of involuntary bodily harm. Now, the most common form of defense brought forward by the accused in cases concerning workplace accidents is contributory negligence. As a defense, contributory negligence does not relieve the accused of any punishment whatsoever, but at least it may mitigate the punishment to a less severe sentence. So basically, that was the criminal aspect. Now, let's move to civil liability. So we've seen that the objective of criminal law is to punish through fines and imprisonment. Civil law, on the other hand, has a different objective. The objective is to compensate the injured party. In fact, civil liability and health and safety is mainly concerned with an action for damages. Now, in cases concerning workplace accidents, civil liability may arise either in contract or in tort. Liability under contract law is primarily based upon the non-performance of an obligation. So, if you're an employer, the obligation is to ensure the health and safety of your employees. On the other hand, liability in tort refers to situations that occur in the absence of a contract between the victim and the person causing the damage. Tort is mostly concerned with the concept of fault. Now, the most distinctive feature between tort and contract concerns prescription. Basically, prescription refers to the period the injured party has to institute an action for damages. In the case of contracts, the period is of 5 years, and in the case of tort, the period is of 2 years. However, if the action for damages arises from a criminal offense, like for example involuntary homicide, then you have to follow the rules of prescriptions of criminal actions laid down in the criminal code. Having said that, there's also a prescriptive period provided in the Occupational Health and Safety Authority Act, which is quite long. In fact, it's a period of 6 years. So there's liability under contract and liability under tort. Now, in cases concerning workplace accidents and also occupational diseases, liability was generally seen through the lens of tortious liability. However, by time the court started shifting to contractual liability. Having said that, if we examine local judgments, you would know that courts have held that employer's liability is both contractual and tortious. So basically, we have a mix of contract and tort. Now, in cases of contextual liability, one would need to refer to Article 1125. According to this article, a person who fails to discharge an obligation which he has contracted shall be liable for damages. As I said, in the case of an employer, the obligation is that of ensuring the health and safety of your employees. And this obligation arises once there's a contract between an employer and an employee. In fact, as held by the Civil Court of Appeal in Carmena Fenech versus Chairman Morta Dry Docks, the moment an employment contract is signed between an employer and an employee, an obligation is immediately imposed upon the employer to ensure the health and safety of his workers. Therefore, once there's a contract, there's an implied duty of care upon the employer. So if there's a civil action, the plaintiff must show that there was a contractual obligation in his favor, and obviously that the defendant failed to fulfill this obligation. Now, with regard to liability in tort, this is addressed by Articles 1031, 1032, and 1033 of the Civil Code. In brief, Article 101 provides a cardinal rule that every person shall be liable for the damages which occurs through his fault. As I said, the law of tort is concerned with the concept of fault. Now, according to Article 1032, a person is to be deemed at fault if, in his own acts, does not use the prudence, diligence, and attention of a bonus pater familias, basically a reasonable person. And fault also includes an omission of duty imposed by law, which is addressed by Article 1033. Again, the concept of foreseeability also features in civil cases. It's an important concept in the determination of negligence. In this regard, the courts have made it clear that risk must be foreseeable. So you can't expect an employer to act against risks which were not foreseeable. However, if there's an observance of law which obviously resulted in an injury or death, that would be a different story. Why? Because in such a situation, the person would be liable not because he failed to foresee the accident, but because he failed to comply with health and safety regulations. So the important question is, how can I foresee the risk of an injury? You can do so through the process of risk assessment. So for a person to be liable in damages, it's not enough to show that he acted negligently. You must also show that there was a causal link between the damage and the actions or omissions of the defendant, the person causing the damages. The causal link and damages must also be proved in the case of contract. So basically, the plaintiff has to establish fault, damage, and the causal link between the two. Contributory negligence is a defense which constantly features in cases concerning workplace accidents. Here we're talking about situations where the plaintiff's own carelessness contributed to the damage suffered. Put simply, such negligence would arise from failure to ensure one's own health and safety, and as a defense, is regulated through Article 1051 of the Civil Code. This article makes it clear that if the injured party contributed to the damage, the court would reduce the amount of the damages payable to him by the defendant. So basically, the court is sort of punishing the victim for having been negligent himself. And in my opinion, this is quite fair. I mean, everyone has to be responsible for his own actions. The case of Fenech versus Jackson's Company Limited is a typical case showing the concept of contributory negligence. Unfortunately, this case concerns a workplace fatality involving a 17-year-old worker. The victim was employed with Jackson's Company Limited and fell to his death from an unguarded balcony in a construction site. In this case, the court observed that both the employer of the victim as well as 10-year stays limited in its capacity as the owner of the site, were negligent and failed to take the necessary measures to ensure a safe place of work. In awarding compensation for the damages, the court remarked that although there was a blatant disregard of health and safety, the victim had also contributed to his death. It also said that although the worker was only 17 years old, he was still expected to be well aware of the risks of accessing an unguarded balcony. Since the victim was also at fault, the court reduced the amount of compensation by 40% so as to reflect contributory negligence. So basically, that was the concept of civil liability. Now, in this slide, I've listed the 6 most frequently cited duties by multi-scores in cases concerning workplace accidents. So basically, we have the duty to carry out a specific risk assessment, the duty to ensure a safe system of work, and the duty to ensure a safe place of work. I'll cover these 3 in the coming slides. Then there's the duty to provide supervision. Basically, employers have to provide supervision as is required to ensure health and safety. So supervision varies from one situation to the other. Now, the type and level of supervision will depend on various factors, like, for example, the type of hazards and risks that may be present at the place of work, and also the type of worker involved. If it's a worker, for example, a young person, a breastfeeding person, a pregnant worker, or a mother to a certain extent. These are all vulnerable persons. So basically, the level and type of supervision will also depend on the person carrying out the duty. Now, be aware that vulnerable persons, such as young workers, require a higher level of supervision. In fact, according to the Young Persons at Work regulations, young workers have to be supervised by a competent person. Then there's the duty to provide training and information. These two are specifically dealt with in the general provisions for health and safety at work regulations. Basically, these regulations make it clear that workers have to be provided with adequate training and information. Please be aware that training has to be specific to the workstation and to the task assigned. So, generic training is not considered to be adequate. The General Provisions Regulations also list the instances where workers have to be provided with the necessary training. And finally, we have the duty to provide a safe work equipment. In my opinion, one of the most important duties imposed upon employers is the duty to carry out a risk assessment. Now, risk assessment is a careful examination of what in your work could cause harm to people, like, for instance, an unguarded machinery or excessive noise. The risk assessment would also highlight the measures that you have to implement to address the identified hazards and risks. As you can see from the text of Regulation 10, the risk assessment must cover all hazards and cover also all aspects concerning work activity. Put simply, a generic risk assessment is not enough and would not be considered to be suitable and sufficient. It has to be specific, and it has to cover all work activities, procedures, and hazards. The risk assessment must also be carried out by a competent person in occupational health and safety. A case which addressed this aspect was Irpulsia versus Joseph Court case. In this case, unfortunately, a worker lost his life after suffering chemical burn injuries while using a particular chemical. Now, in this case, the Court of Appeal remarked 2 important issues: that the person who carried out the risk assessment was not competent in health and safety, and that the risk assessment did not cover the procedure and use of chemicals. So, although the risk assessment covered the procedure of glass cutting, it did not cover the use of chemicals, so it wasn't considered to be suitable and sufficient. The message constantly repeated by courts in civil and criminal cases involving workplace accidents and occupational diseases is the importance of managing risk through a safe system of work. Now, a safe system of work is a formal procedure that defines the safe methods that must be followed by workers to work safely. So, work activities have to be covered by a safe system of work. It's very important that such systems are regularly reviewed to ensure that they are still valid. Employers must also ensure a safe place of work, an environment where hazards are identified and addressed through a series of preventive and protective measures. So basically, you have to keep your workplace free from hazards and to make sure that it's compliant with health and safety regulations. Now, this is very important. The obligation to provide a safe place of work extends beyond the four walls of the employer, meaning that such duty also extends to situations where an employee is working off-site at a client's facility. So basically, there's an extension of the duty to ensure a safe place of work. Unfortunately, accidents due to unsafe work equipment are quite common. Now, work equipment is specifically regulated by the Work Equipment Minimum Health and Safety Requirements regulations. These regulations make it clear that work equipment has to be suitable for the work to be carried out or to be adapted for that purpose. The message is clear. Work equipment must be used without impairment to the worker's health and safety. These regulations also provide that if there's a risk of mechanical contact with moving parts of work equipment, the employer has to install guards or devices to prevent access to such areas. Il Pulizia versus Ronald Garia is a typical case which concerned an unguarded work equipment. In this case, the victim was operating an industrial food mixing machine and at one point he inserted his hand to clean the remaining residue, and this ended up losing a finger. Although the victim was provided with training and information on how to use this work equipment, the machine wasn't equipped with a cutout emergency switch, so the equipment wasn't safe. In this regard, and this is very interesting, the court held that training and instructions alone are useless if work equipment is unsafe. That brings me to the end of my presentation. If you have any questions or need further information about the duties imposed upon employers and workers, just send me an email on the address shown in the slide. Thank you all for your time and attention.
Thank you very much indeed, Melino.
Let me stop sharing. Okay, is it okay?
Excellent, excellent.
Okay.
Thank you very much. I'm sure we'll have time to ask you some more supplementary questions during the panel discussion. I really found it extremely good and comprehensive. Our next presentation is a presentation by Dr. Mark Gauci, who will give an intervention talking specifically about OHSA resources to support the risk management process. And Dr. Gauci graduated as a medical doctor and later specialized in occupational medicine at the University of London. So we have a lawyer and a doctor talking here today. He has helped set up the Occupational Health and Safety Authority in Malta, of which he has been the CEO since its establishment. So I look forward very much for your presentation. Dr. Gauci, please go ahead.
Thank you very much. First of all, I must thank you, Catherine, and the Malta Chamber for this opportunity for OHSA to participate in this webinar. Although I intended to listen to the speakers before, I was also at the same time keeping an eye on the questions being asked, and I've managed to answer a few, but there are still others coming in, which I hope to be able to answer later on after I finish my presentation. So I will try and share I've amended slightly the title of my presentation and included the question whether OHSA is considered, especially by your good selves and the participants to this webinar, whether OHSA is considered as a friend or foe. It is important to ask such a question, and by the end of this presentation, I hope that you will be able to give an answer to these questions. The scope of my presentation, as Catherine said, is to introduce OHSA to those of you who do not know about this entity, and to briefly provide an overview of the resources which are available, most of which are produced by OHSA, to support the risk management process. I also take this opportunity to list some of the priority areas which I feel there should be more input and various initiatives that are required to be taken to address the concerns which I shall be mentioning. So, as has been mentioned before, the Occupational Health and Safety Authority has been established by virtue of Act 27 of 2000. The SAC was brought fully into force in January 2010, which means that next year we shall be celebrating the 20th anniversary of its activities. It is important to stress that the Act, the OHS Authority Act, is applicable to all sectors of activity, and specifically refers to both public and private sectors, as well as emphasizing that it applies to all workers. Now, it is important to mention this point to highlight the fact that it is not just employees, that is, workers who are employed under a contract of employment by an employer, but also self-employed workers and workers under a contract for service. Now, that is when we talk about the large number of workers in Malta, it essentially means that 295, close to 300,000 persons fall under the applicability of this legislation. And this number, the 300,000, only refers to employed persons. So why does OHSA exist? OHSA exists to ensure that the physical, psychological, and social well-being of all workers are promoted, and that they are safeguarded by whosoever is so obliged to do. Now, the implication from the statement, which is found in the Act, is essentially that OHSA is not responsible for the health and safety of workers. And as was mentioned earlier by Dr. Melina Mercia, it is the creator of risks who is responsible for the health and safety of workers. The Act assigns 12 functions to OHSA, and there are around 30 different sets of legislation, subsidiary regulations, which were issued under the Act. Now, what perhaps has not been mentioned is that the principles which are put forward in the Act are applicable in all the subsidiary legislation. So if the Act establishes the principle that workers have a right to be consulted, then the subsidiary legislation includes that provision, even though it is not stated. Amongst some of the tasks and roles assigned to OHSA, one finds enforcement, preparation of legislation, awareness raising, guidance, provision of information, promotion of training. OHSA does not carry out training. That is a responsibility of employers, and OHSA can only promote training of workers. It keeps and maintains and regularly updates a number of databases and registers. It investigates cases of all incidents relating to occupational health and safety, as well as promotes research. Now, it is important to understand that under the EU treaty, occupational health and safety is considered as a subject which requires social partner participation. Hence, a tripartite approach to occupational health and safety is required. And this is not just required at the macro level, but also in the way by which the various provisions of the health and safety legislation are implemented at the place of work. Now, as I said before, because OHSA is not responsible for the health and safety of workers, it is precluded by law from assuming any duty which has been assigned elsewhere. We still get requests for which are sent or forwarded to OHSA for OHSA to carry out risk assessments. That cannot be done for the simple reason that the law requires an employer to carry out a risk assessment, as has been explained before, and therefore OHSA cannot assume that responsibility for someone else. We have said that we work with others, and that is why we welcomed this opportunity to participate in this webinar with open arms, because OHSA's mission statement is to work with others to ensure healthier and safer workplaces in Malta. Now, whereas I keep emphasizing the fact that it is employers who are ultimately responsible for health and safety, OHSA can definitely facilitate the process. We have done so since our establishment. We have taken on board the principle of better regulation. We were actually one of the first entities in Malta to take this on board, and we started making sure that all health and safety legislation is free from unnecessary or bureaucratic burdens. In health and safety legislation, we have removed all reporting duties except where specifically required. For example, the reporting of injuries, cases of ill health, and so on. We have removed all cases, all instances of permitting. We do not need to ask for a permit from the Occupational Health and Safety Authority, except again in a few specified cases. For example, before starting to remove or handle asbestos containing material. So we work very hard at trying to develop legislation which is simple. Simple legislation does not mean that there is a lesser or rather a decrease in the standard, but legislation which is easier to understand and therefore easier legislation with which it is easier to comply. We have also over the years developed several aids to compliance which assist duty holders to comply with the legislation, as well as providing information and guidance. At the end of the day, we try to encourage self-regulation, and people, because we believe that people should be compelled to ensure adequate levels of health and safety because they perceive the benefits of doing so, rather than having to wait for an OHS officer to come at your place of work and take enforcement action. Now, what is the situation in Malta? First of all, I would say that we have a very well developed legal framework, which, as I said, is free of unnecessary bureaucratic burdens. We have a fair, equitable, and transparent enforcement system. This has been shown time and time again, even by the courts of law, which have pronounced themselves on the matter. OHSA, I feel, and I can only give a subjective view on this matter, but subjectively, I would say that OHSA is a valid point of reference. Again, even the courts of law have made reference to a number of guidance documents which have been issued by OHSA before delivering judgment or pronouncing the sentence. Outside of Malta, OHSA has a very good reputation. And this is important because it ensures that we keep contacts with our peers, we keep contact with those which are there to evaluate the operations of OHSA. And we have very good contacts with the Commission and the ILO, which both entities repeatedly ask for OHSA to be present and form part of different working groups and so on. OHSA is also used as a sounding board, unofficially, of course, but it is used as a sounding board before the Commission even starts to think about introducing new legislation. We have often been contacted by the Commission, by the Directorate for Occupational Health and Safety about intended courses of action or initiatives which the Commission would be thinking of taking. Now, I keep saying all along that in fulfilling its functions, it has to consider that there's an art of striking a balance between all the functions, the 12 functions that are assigned by the OHS Authority Act. I'm not going to stay listing all the numbers of our outputs, but one can see that the outputs are quite substantial. There are many other functions which are not listed in the Act. For example, we give lectures at the University of Malta in various faculties. We fulfill international obligations. The Act never mentions that OHSA has to represent Malta and Malta's interests abroad, but we still take on such an onerous responsibility. We also make sure that our staff remains conversant with all the developments in the field. And that is one way of ensuring competence, which is constantly changing, as it needs to take into consideration the changing world of work, technological developments, the introduction of new chemicals, and new approaches concerning occupational health and safety. So we work very hard at keeping our staff updated and up to scratch. I did mention that we prepare a lot of guidance material. I'm not going to list all the guidance material. This can be found on the website, which is currently being used by OHSA. All the guidance prepared by OHSA is free of charge. It is fully downloadable, and it can be used without any condition, except perhaps to recognize the source. We have tried also as much as possible to issue guidance related to particular periods of time. COVID-19 is one such case where we have been very proactive in producing guidance. Suffice it to say that the guidance prepared and issued and circulated by OHSA was used by the European Agency for Safety and Health even before the agency has started preparing its own guidance. But the agency required, or rather asked OHSA, invited OHSA, and asked for its permission to circulate the guidance prepared by OHSA as example of good practice to all the member states. And that is, I feel, a feather in our cap. Again, just a few more examples of the generic guidance, like working in the sun and heat and so on. Now, something which I would like to make you aware of, for those of you who do not know what this is the online interactive risk assessment tool. Now, this is a tool which the original concept was thought of by the European Agency for Safety and Health. And this is an online tool which assists a duty holder or anyone else who has an interest in carrying out to perform a risk assessment. Now, it is interactive. That is why online interactive risk assessment tool, because it provides a template. The person filling in or carrying out the risk assessment has to answer a number of questions. And at the end of this exercise, the tool itself prepares for you a plan of work. So it identifies and prioritizes all the work that is required to be taken based on the risk that the person doing the exercise himself or herself assigns to that particular task. Now, in Malta, we have various tools which have been developed and which are available in both Maltese and English. Unfortunately, it is not something which we could continue and prepare as many tools as we wish to do, for the simple reason that the agency changed its model. And whereas before the labor inspectorates were able to prepare such tools themselves, there was a decision taken by the European Court of Auditors which concerned the utilization of the labor inspectorates to carry out such tasks. And the European agency was compelled to contract out such a service to competent persons. Unfortunately, when they asked for people who were interested to carry out such a task in Malta, and there were several people and groups of people who had applied were deemed to not have the required criteria as would allow the preparation of such tools, which is indeed a shame and something which I wish could have been arranged in a different way. We also organize a lot of information campaigns. And this is something which in future we could work with the chamber in identifying a topic. Some of these are related to Europe-wide campaigns, and they are organized under the aegis or under the control of the Senior Labour Inspectors Committee or the European Agency for Safety and Health. But there are several other European campaigns which have a local focus. For example, Building in Safety was a local campaign. I'm trying to identify some. Management of dangerous substances. The current one, which was intended to start last year, but because of the onset of COVID, only started this year, concerns musculoskeletal disorders. And it is intended as an information campaign. Our officers will soon be receiving training from the lead Labour Inspectorate, who has assumed the role of managing this campaign, and the information that can be obtained from this training program can be disseminated even in Malta at a later stage. Now, something which I would like you to refer to is the so-called ESNER study, which is the European Survey of Enterprises and New and Emerging Risks, because this helps us to identify the situation, the level of compliance, as well as it gives an indication of how people perceive occupational health and safety and the state in which it is in. Now, the last ESNER study, that is why ESNER is an acronym for European Survey of Enterprises on New and Emerging Risks. Was carried out.
Try to close soon, please.
Sorry?
I said if you could try to close soon, please.
Yes. Okay. So, according to the survey, one of the questions asked was, from whom do you obtain guidance and information? And almost 100% of the respondents say that they obtain information from the Labour Inspectorate, which is OHSA. 28% of respondents said that they obtain information from employers' organizations, and interestingly enough, 11% from the unions. This is an interesting slide because the Framework Directive requires all enterprises and all companies and all employers to have their own in-house competent setup. And this shows the difference between those workplaces. In Malta, we are faring quite well, because close to 90% of the workplaces interviewed said that they do carry out regular risk assessments, but around 30%, just over 30%, said that this is done in-house. Reference was made to the health and safety policy. Again, in Malta, not many believe that the policy, just under 60%, has any value. Stress at work, because stress was mentioned, Malta is here at the bottom, when ideally a country can be described as faring well if it is in this segment of this histogram. In Malta, few people concern stress to be a major concern at work, and at the same time, few reported that there are procedures at work concerning stress at work. I will skip a few slides, and I'll just finish on with this last one. First of all, social partners need to be more proactive. OHSA should not be the one all and be all. Obviously, one has to embrace the future because of the changing world of work, new technology, different risks, and so on. And always keep in mind that the legislation lists minimum requirements, and it requires that all workers the health and safety of all workers should be respected in every aspect related to the work that has been assigned. I don't think that there is this, but all right, the last slide, and I will close. Stress at work, what can be done? At a European level, there is the so-called framework agreement on the control of work-related stress. Now, in Malta, OHSA provided its own framework based on the European agreement, but unfortunately, this is something which needs to be implemented by the social partners, the employers and unions. In its implementation report, the Commission reported that in Malta, there was little or no reports of activities taken by the social partners. And that is something that we have to work on. There's everything, there are the tools, there's the framework, and that is something which can be promoted and worked upon. Thank you.
Thank you very much indeed. I thought when Dr. Gauci had joined us as a meeting a few months ago now, one of the things we found very interesting was the number of tools which are available to support employers. And I think the health and safety risk assessment tools, for example, a pity we can't continue with them, are excellent. So I really encourage people to have a look at them because they can support us quite a lot. I'm very pleased at this point to introduce Gaston De Giovanni, who hasn't spoken so far. Gaston will join the panel at this point, so we'll be addressing particular questions. So Gaston is a fire engineer by profession. He's a loss adjuster advising on settlement of insurance claims. He holds a BSc honours in occupational health and safety and has in fact decades of experience on loss adjustment and doing fire safety engineering design on major projects, high-rise developments and special risks. So I'm going to take the liberty of addressing the first question to Gaston because we had a number of questions on this subject even prior to the seminar, to the webinar. So Gaston, could you just for a couple of minutes describe the practice in the local insurance market on settlement of injury claims? And specifically the effects, for example, if risk assessments had not been carried out. What is the practice in the insurance market in general when settling claims?
I think, we have to start off by making a distinction insofar as the insurance market is concerned when we are dealing with employers' liability claims and personal accident claims. The biggest distinction, in my opinion, is that in a personal accident policy, where for a company would have a group personal accident, because obviously there are a number of people involved, this is essentially a benefits policy. So primarily, all that needs to be shown is that an accident has happened and the policy will respond. This having been said, there is a big caveat because every policy has its own exceptions, okay? Both an employer's liability policy, which, like I said, deals with liability issues, and a personal accident policy. Most companies, most reputable companies, and I believe that locally most companies are reputable here, if there is an accident and there is no prima facie breach of the general duties or obligations or a general policy condition, they will proceed with settling the claim. If, however, there is a blatant breach, especially when this breach relates to a legal requirement, and the previous speakers on this panel have highlighted what these requirements are, these legal requirements are, then the insurance company has every right to refuse to settle that claim, especially, and I think this is the general rule as well, if the breach is not related to the accident. Now, just dealing with a personal accident policy on itself is not going to cover the employer for all the exposure that he faces. And by that I mean, a personal accident policy is a benefits policy where the benefits are predetermined actually at the time of taking out the policy. So for example, there is a fixed scale or a fixed sum for what happens in the event of death or personal injury, which could either be of a temporary nature, that is referred to as a temporary total disablement benefit for that period, which the policy specifies, that is the maximum period, or if it's a shorter period because the employee would have recovered before. But that amount might not be sufficient for the heirs, especially in a fatal accident, of the injured party. And this is where the employer's liability policy comes in. The reason for that is the employer's liability policy has a much higher limit of liability, which is basically the maximum amount that an employer will pay. That amount, however, is determined by the courts. So if the employer is found to be liable in court, okay, so there has to be a civil action, unless there are obviously out-of-court settlements, but let's put those aside for the moment. If there is an award up to say 100,000, 150,000, 200,000, and the employer is found to be at fault, assuming there is no contributory negligence and there are no breaches of policy conditions, the employer's liability policy will pay out. The same principles which were mentioned by the previous speakers, especially those of contributory negligence, will apply. Okay, but other than that, it is that amount which is determined and not the predetermined amount of the personal accident policy. If, however, there is a blatant breach of either a legal requirement or a policy condition, for example, that the policy might specify, this is a very basic example, but that no woodworking is carried out, and the employee was injured because of he was involved in doing woodworking, then the policy has every right to refuse. The same applies if there is no risk assessment or the risk assessment is not detailed enough or adequate enough. Then the employer has a right to challenge the claim being made against that policy. I repeat, normally, if the breach is not directly related to the accident, insurers will not take a very strict approach. At least that is my experience in the market. If, however, it is directly related, they have every right and are within the rights to repudiate the claim. And then the employer is faced with two actions. One, obviously, from the injured party or his heirs or his family against the employer, and the other one he himself would have to institute against the insurance company. One final point is that the insurance policy will never pay for fines or anything else related to a criminal offense. So if the employer is fined, whatever the fine is, because of breaches of health and safety regulations, that is not something that the policy will pick up.
Thank you very much indeed, Gaston. Very comprehensive. I would like to address a second question. First of all, I'd like to know, just comment that there's been a number of very interesting questions, and Melino and Mark have very diligently given answers. So if people would like to look them up, perhaps we can circulate these after the meeting as well, because it's quite good to have this together with the presentations. There was a question about the presentations. I believe we can pass on the recording as well. So I'd like to address the second question to Melino Mercea, in fact. This relates to liability issues for directors and officers when they employ professionals. So in the context of health and safety, if you employ someone who you believe and who is qualified more than you are to assess certain risks, and that person makes an error of judgment, what is the extent of your own liability in that case?
Well, thank you, Catherine, for the question. First and foremost, the fact that an employer appoints health and safety officer or enlists external services does not relieve him from his duties to ensure the health and safety of his employees. That's clear. The duties would still apply. However, I'm not saying that as an employer you would always be found liable no matter what, since there are cases where employers were not found guilty of causing involuntary homicide or involuntary bodily harm. Why? Because it was shown that the accident had been caused by the sole negligence of the victim himself. So when you appoint someone, like for instance, again, a manager or an engineer, whatever, you have to ensure that such person is competent. If the position requires a particular skill, then you have to make sure that such person has indeed the skill. Why? Because if someone is injured due to the incompetence of such person, then you may be found responsible due to your failure to appoint a competent person. It's culpa negligendo. As an employer, you're expected to employ competent persons and to reasonably monitor the actions performed by these employees. But in situations where the employer has appointed someone who's competent and such person causes an accident due to his own negligence, then why should the employer be found guilty? So the employer has to show that he appointed a competent person, and this issue is also reflected in the Occupational Health and Safety Authority Act. In fact, the Act makes it clear that where an employer appoints a person to assist him in the implementation of measures, he must ensure that such person has the necessary competence and training. So if you employ an incompetent person, then you're assuming liability that arises out from such incompetency. On the other hand, if you employ someone competent, then you should not be found responsible for the damages that they cause, because that would be the responsibility of the competent person. Now, don't forget that in cases concerning breaches of health and safety, the onus of proof is shifted onto the accused, and that the accused has to show that it was not reasonably practicable to do more than what he has done. And this is the same in the case of Article 13, which concerns directors. There's a presumption that the director is guilty of an offense unless he shows that the offense was committed without his knowing, and he also shows that he done everything possible in his power to prevent the offense from happening. So if you were diligent in the appointment of the health and safety officer or another professional, and you didn't remain passive despite such appointment, then you should not be found guilty because of the negligence of such persons.
Thank you. I think this point about keeping track, keeping records and proving is really, really important. And
yes, it is.
I think this documentation, and Martin made this point even in his own presentation when he talks about the importance of the file and having adequate records and proof of both your policies, your health and safety risk assessment. So Martin, I'm going to address the next question to you specifically, talking about work-related stress over here, which has come up a couple of times, and key stressors for especially on the part of employees include harassment and bullying, and these sometimes border on gender issues. And I wanted to ask you if you have any comments about these particular issues and how employers can mitigate risk in relation to these issues.
Okay, thank you, Catherine. I believe there are some steps which an employer must take to ensure that he addresses claims relating to harassment, discriminatory treatment, and bullying. The first step is having clear policies which are easily accessible by all employees and which set out acceptable and unacceptable behavior at work. Secondly, an employer should also have a grievance policy in place, which sets out the steps to be taken by an employee who wishes to raise a complaint. Finally, also, the employer should promptly investigate any claims relating to harassment and also bullying and discrimination, and take action if necessary following the conclusion of any investigation. It is simply not enough for the employer to plead they were unaware of unacceptable activities going at work. An employer should be able to prove that they were proactive in preventing such activities from going on.
Thanks very much indeed, Martin. My next question is related to health and safety and COVID. Dr. Gauci, maybe you can comment a bit about remote work and health and safety, because COVID has, not in all organizations, but COVID has affected us, has affected many of us in the sense that a number of our employees are working remotely, and many are now setting up hybrid work systems where people will be partly working from home and partly working in an office environment or other industrial environments. So if you can comment, please, on that, that would be great.
Yes, I did mention this before, but an employer remains responsible and has to ensure the safety and health of workers in every aspect related to work. And this also implies that any workers who are allowed or required to work remotely also fall under this umbrella statement. Now, essentially, this means that an employer is also responsible for the remote work. However, insofar as OHSA is concerned, we have provided a slightly different understanding and interpretation of this requirement, in the sense that an employer is only responsible for the workstation if it is provided by the employer. For the tools that are provided by the employer, laptops, computers, and so on. For the software that the worker is requested to use, one common cause of stress at work is that workers are expected to use software for which they have received no training, and that causes psychological stress as well. The employer, on the other hand, is not responsible for the safety within the building. For example, we have seen risk assessments where the working remotely is asked to assess and list all the fire alarms within a house, for example, or whether there are enough emergency routes and exits within a residential building. In our opinion, that doesn't make sense. We have to keep in mind that remote working is associated with a certain degree of flexibility. Now, this is not always the case, but in the majority of cases, there is this flexibility which is associated with the remote working. A worker may choose to work from a public coffee shop, for example. Now, is the employer going to be responsible for the safety within that coffee shop? It wouldn't make sense to do so. Having said that, because COVID remains a problem, the recommendations and guidance issued by the health department are still in force. And where possible, and there are other reasons as well, economic reasons as well, workers should be allowed to work from home if the work permits such a situation.
Thank you. Thank you. That's a consoling answer. Thank you very much. Gaston, I'd like to address another point, which again, I had a lot of feedback about this prior to this webinar, about high-rise. We know that there is some talk about and work on a new Fire Safety Act, particularly in relation to high-rise. Can you make some comments about this new act and its provisions, and possibly if there are any other issues that you would like to highlight about high-rise and fire safety?
Okay, well, let's start off with the regulations themselves. These are the fire safety regulations. They're dated 2018. There's some discussion still going on, and hopefully they will be put in place shortly. The act, these regulations, in my opinion, we've been requiring these regulations for years and years and years. In a way, they are very similar to a number of regulations as OHSA regulations. And that but the only difference being that they specifically apply to fire safety. One of the main things that comes to mind immediately upon going to the regulations, that it is now formalized that it's a criminal offense not to have a place where the necessary fire safety features are in place. It deals with most of the aspects of fire safety, emergency exits, alarm systems, etc., etc., etc. But I think, again, in my opinion, one of the most important features of these regulations is that it is now recognized that people, employers, developers, whoever it may be, the owner of the building must appoint a competent person to ensure that the building is safe, again, from risks of fire for everyone who is in it. And that includes not just workers, obviously, but anyone who visits those premises. There isn't enough time to go through all the requirements, but what I can tell you is, like I've already said, it is now a criminal offense not to either appoint a competent person, and there are various definitions of competency, depending on obviously what the building is, the trades carried on or the work carried out within the building. And like I said, it is a criminal offense. The fines being envisaged are substantial, up to 50,000 euros. Not only that, but you can also get fined up to a maximum of 50,000 plus 5 years in jail. There is also a provision that the statute of limitation or time bar period is actually 5 or 6 years in this. That's insofar as buildings in general are concerned. Your next point was when it comes to high-rise fire safety. I think we have to understand that given the number of high-rise construction that is going on, high-rise provides a totally different fire safety challenge, primarily because it is a fact, not just in Malta, but everywhere, that the fire brigade appliances, the vehicles that they use, cannot reach beyond a certain height. So above that, there is no help. Unfortunately, you cannot have any help from the CPD, in this case, which is the Civil Protection Department. So the building itself must provide facilities for the CPD, as well as the people who are in it. High-rise fire risks are entirely different to a low-rise building, and that is because of the very nature of how fire behaves. To put it bluntly, a fire will travel upwards, smoke and heat will travel upwards. So if you have a 15, 20-story building, which are quite common here, we're going even higher than that, and you have a fire on the 2nd or 3rd floor, unless the necessary measures are in place, and by measures I mean necessary fire protection systems, smoke and flames and heat will travel to the upper levels. So all of a sudden, and this is perhaps where it may vary from other occupational health and safety risks, there is a risk of not just 1 or 2 people becoming affected, but a greater number of people. The more the number of floors, obviously the bigger the risk, especially when it comes to evacuation of the people. You simply cannot evacuate 20 floors at one time through a building, unless you have what are referred to as protected staircases, you have automatic suppression systems, you have ventilation systems, and a number of other things. There are codes, there are international codes of fire safety, which unfortunately, I must admit, are not necessarily being followed all the time when it comes to local construction. There is also an issue of the materials of construction when it comes to fire safety. Fire can jump literally from one floor to the next, or even in certain cases, what we call leapfrogging, jumping a number of floors. For example, a fire on the 5th floor all of a sudden will along the facade of the building will jump to the 8th or 9th floor. It creates major panic, and the risks of fatalities is very, very high. The requirements or competencies for designing against the fire risk in high-rise buildings is, and this is, I think, a very critical point here, is entirely different to designing fire safety in low-rise buildings, and that is because of the mechanics of the fire. A lot of people still, we come across this practically every week, if not every day. We still are under the misconception that concrete or limestone block, which are the 2 most commonly used building materials locally, does not burn. Yes, concrete does not burn and limestone does not burn, but limestone does not spread fire, does not stop the spread of fire and smoke, and concrete will lose its structural stability. So there is a serious risk of collapse unless the concrete is either properly designed, and by properly designed I mean the rating of fire resistance, or the necessary fire protection measures are not put in place. We also have a substantial number of buildings where, these are especially the residential apartments, residential blocks, where the entire block, whether it's 8, 9, or 10 floors, is served by a single staircase. We are still seeing cases where, fine, you have a single staircase that is permitted, but there are no fire doors on the apartment. What that means is that if there is a fire in the apartment, it's going to spread quickly into the single staircase, and all the people in this block of apartments are literally trapped inside. I'll just conclude by saying this. They're not given as much media coverage as perhaps is necessary, but we have had a number of very serious commercial fires locally, literally running, the insurance industry knows this because they have to pay for it, literally running into millions of euros. Okay? But perhaps more serious than that is that we have had a number of fatalities, even in residential apartments. And this simply because a developer or whoever is responsible, I don't want to point fingers at the developers because that's not the intention of this system, but someone fails to specify that the apartment door has to have a fire rating, so that if there is a fire inside, okay, the staircase, the means of escape are not prejudiced. The last point I would like to make is that everyone seems to be very happy about these new fire regulations, and so they should be. But the fire safety regulations are only concerned with the protection of human life. They are not concerned with the protection of property. That is not the scope of the regulations. The protection of property is the responsibility of the building owner if he wants to protect his property, the insurance market, and in some cases, the banks. Why? Because obviously a lot of developments involve financing. And if there is a serious fire and the insurance market, the insurance company, the respective insurance company, whoever that may be, refuses to settle a claim, either because there is a breach in policy conditions or for whatever justifiable reason, the bank is going to be exposed as well. And I think we need perhaps more, and there are discussions being carried out with the Insurance Association actually on this. But the point remains that the fire safety regulations, which, like I said in the beginning, will hopefully come into force shortly, are only concerned with the protection of human life and the protection not just of the people inside the building, but also of Civil Protection Department personnel who may be called in a fire emergency.
Thank you very much indeed, Gaston, on that very sober end note. And I wish to state that maybe we should be looking a bit more about this issue, and there needs to be, as you said, a bit more publicity about people. There is not enough awareness. This was step one, and perhaps the Chamber and perhaps the Health and Wellness Committee should take this further. There needs to be more awareness about the risks associated with high-rise, both to human life and to property. Just to generally make a comment overall, I'd like to thank you very, very much, all the participants and all the speakers. And maybe I can just summarize by saying, when it comes to occupational health and safety, the following mantra should be chanted: assess the risk, document that you have assessed the risk, communicate the risk, and make sure that you train. Thank you again, Tim, for your coordination and organization. And thank you again, Peri Chwirep, Dr. Zmon Gauci and Melino Merce from the OHSA, Mr. Martin Bondin and Mr. Gaston De Giovanni, and all of you for your time and involvement. Thank you very, very much.
Thank you all.
Have a good evening.
Good evening, everyone.
Good evening. Thank you. Well done.